A 73-year-old widow in Brooklyn owned her home free and clear for 19 years. No mortgage. No liens. She paid her taxes every year, kept the yard maintained, and slept in the same bedroom she had shared with her late husband. Then one afternoon, a stranger knocked on her front door and told her he was the new owner. He had paperwork showing a recorded deed transfer at the county recorder's office. A deed she never signed. A transfer she never authorized. And under the law, until she could prove fraud in court, his name was on her house. The document that controls whether your home belongs to you, your children, or a complete stranger is sitting in a government office right now. It is public record. Anyone can look at it. And if someone has changed it without your knowledge, you may not find out until they show up at your door or a lender files a claim against your property. The document is your property deed. And if you have not verified it in the last 12 months, today is the day. *** what title theft actually looks like in 2026. Deed fraud is not a hypothetical crime. According to the FBI's Internet Crime Complaint Center, real estate fraud generated over 9,000 complaints and $173 million in reported losses in a single year. Of those, roughly 1,765 complaints came from Americans aged 60 and older. That group made up about 19% of the complaints but absorbed nearly 44% of the total losses. $76.3 million taken from seniors alone. In April of 2025, the FBI's Boston division issued a specific warning about a surge in quitclaim deed fraud. The scheme is straightforward. A criminal identifies a property, typically a paid-off home with significant equity and an owner who is elderly, living alone, or living out of state. They forge the owner's signature on a quitclaim deed, a document that transfers ownership without any warranty or title search. They file that forged deed with the county recorder's office. And once it is recorded, it becomes part of the public record. From that point, the criminal can do one of three things. They can take out a mortgage against the property and disappear with the loan proceeds. They can list the home for sale to an unsuspecting buyer. Or they can pose as the landlord, rent the property to tenants, and collect payments for months before anyone catches on. The reason this crime disproportionately targets seniors is simple. Older homeowners are statistically more likely to own their homes outright. They are more likely to have decades of built-up equity. And they are less likely to check digital property records or monitor their credit reports with the frequency needed to catch a forged deed before damage is done. How to check your deed in the next 10 minutes. Verifying your property deed does not require a lawyer. It does not require a fee in most counties. And it does not require leaving your house. The majority of counties in the United States maintain an online portal through their recorder's office, sometimes called the Register of Deeds or the county clerk's office, where property records are searchable by name, address, or parcel number. Go to your county's website and search for Recorder of Deeds or Property Records. Enter your name or your property address. The system will display every recorded document associated with your property, including your deed, any liens, mortgages, and any recorded transfers. What you're looking for is straightforward. Your name should appear as the current owner. The most recent recorded deed should be the one from when you purchased the home or when ownership was last legally transferred to you. If there is a recorded document you do not recognize, quitclaim deed, grant deed, or any transfer that you did not authorize, that is a red flag that requires immediate action. If your county does not have an online portal, you can call the recorder's office directly and ask them to confirm the current owner of record for your address. This takes less than 5 minutes by phone. The free alert system most homeowners have never activated. Here is something that could have prevented every single case of deed fraud described in this video. Hundreds of counties across the country now offer a free property fraud alert service. You register your name with the county recorder's office, and any time a document is filed in the public record using your name, you receive an automatic notification by email or phone. This means if someone attempts to record a forged deed, fraudulent lien, or any unauthorized document against your property, you are notified immediately. Not 3 months later when a bill arrives. Not 6 months later when a stranger knocks on your door. Immediately, the moment the document hits the recorder's system. This service is free. It takes about 2 minutes to set up, and it runs continuously until you cancel it. The recorder's office in your county may call it a property alert, deed notification service, or a fraud watch program. Search your county name followed by property fraud alert and you will find the registration page. If your county does not offer this service directly, your state's Attorney General office may operate a statewide version. Several states have launched centralized property alert systems in the last 2 years, specifically because of the rise in deed fraud targeting older homeowners. The document that keeps your home out of probate court. Now that you have checked your deed and confirmed no unauthorized changes have been made, there is a second question you need to answer. What happens to this property when you are no longer here? If your deed is a standard grant deed or warranty deed with only your name on it, and you have no will or trust that addresses the property, your home will go through probate when you pass away. Probate is a court-supervised process that can take 6 months to over a year, cost your heirs thousands of dollars in legal fees, and delay their ability to sell, occupy, or manage the property. There is a document that eliminates this entirely. It is called a transfer on death deed, also known as a beneficiary deed. As of 2026, 32 states plus Washington, D.C. recognize this document. It allows you to name one or more beneficiaries who will automatically receive ownership of the property upon your death. No probate, no court hearing, no attorney fees for the transfer itself. Here is what makes this document different from adding your children to the deed as joint tenants, which is what many seniors do instead. When you add a child to your deed, they become a legal co-owner immediately. That means their creditors can place liens against your home. Their bankruptcy can affect your property. Their divorce could complicate your title. And you may lose the ability to refinance, sell, or take a reverse mortgage without their written consent. A transfer on death deed avoids every one of those problems. You remain the sole owner for the rest of your life. You retain full control to sell, refinance, or change your mind. The transfer only takes effect at death. And because the beneficiaries have no legal ownership interest while you are alive, their financial problems cannot touch your home. To create one, you fill out a state-specific form, have it notarized, and record it with your county recorder's office. In some states, you also need 2 witnesses. The recording fee is typically between $15 and $50 depending on the county. And once it is recorded, it overrides any previous transfer on death deed you may have filed. So updating it is as simple as filing a new one. If your property is in a state that does not recognize transfer on death deeds, the alternative is a revocable living trust, which accomplishes the same goal but involves more paperwork and typically requires an attorney to set up properly. The homestead protection you may have never filed. There is one more document connected to your home that most homeowners over 65 have never reviewed. Nearly every state offers a homestead exemption that reduces your property's taxable value, protects a portion of your home equity from certain creditors, or both. Some states apply this automatically. Others require you to file a 1-page application with your county assessor's office. If you turned 65 after you originally filed your homestead exemption, or if you never filed one at all, You may be missing a senior-specific enhancement that increases your protection. Multiple states expanded their senior homestead exemptions within the last 2 years. Some now reduce your assessed value by tens of thousands of dollars. Others freeze your assessment entirely so that rising property values in your neighborhood do not translate into a rising tax bill. This filing is separate from the standard exemption and must be requested independently. If you have not checked your homestead exemption status since turning 65, contact your county assessor and ask 2 questions. Is my homestead exemption active? And am I receiving the senior enhancement? 3 things to do before the end of this week. First, look up your property deed at your county recorder's website. Confirm your name is on it. Confirm no unauthorized documents have been filed. If anything looks unfamiliar, contact the recorder's office, file a police report, and consult a real estate attorney immediately. Second, register for your county's free property fraud alert. This takes 2 minutes and gives you real-time notification if anyone files a document against your property. Third, determine whether your state allows a transfer on death deed. If it does and you do not have one recorded, this is the simplest, least expensive way to ensure your home passes directly to your family without probate. If your state does not allow it, explore irrevocable living trust with an elder law attorney. Your home is likely the most valuable thing you own. The documents that control who owns it, who inherits it, and who can claim against it are sitting in a government office right now. Make sure they say what you think they say.